Good morning.
Hang on, Mr. Thompson. Give me
Okay.
just a minute. It is still good morning. Let me express the appreciation of the court for y'all's flexibility in the schedule. Our next case is Long versus Fowler et al., and we will hear from the appellant.
Thank you, sir. And it's our intention to reserve 5 minutes for rebuttal. My name is Sanford Thompson from the Wake County Bar. Here with me today are John Paul Godwin and Michael Sivis, also of the Wake County Bar. We represent the estate of Joe Long. And we are here today to discuss a case that summary judgment was entered in. There's a lot of material in the record and in the documentary briefs, over 2,000 pages. And so I would commend to the court Plaintiff's Documentary Exhibit 51. This, we contend, is probably the most important single thing out of those 2,000 pages. It is the cover for the control manual for the chiller HVAC, heating, ventilating, and air conditioning machine that the defendants were responsible to take care of that caused the problem. And the first sentence on the first page of the manual warns of the hazard of system pressure. It warns installing, starting up, or servicing this equipment can be hazardous due to system pressures. The first sentence under safety considerations speaking to the people that will work around this machine. So we contend that that is very important because it should be foreseeable to heating, ventilating, and air conditioning men like the defendants who were working on this machine, who were responsible for this machine, to understand this. Why? Because system pressure within the machine from high pressure refrigerant gas that the defendants knew was there, actually, when they shut down and secured the machine, they didn't take care of the system pressure. They capped it, and then the cap that they installed blew off, hit Joe Long in the head, and he died 5 days later. So the very hazard that the manual leads off with is what was the cause of Mr. Long's death, system pressure. Now, these men had never drained or secured this machine. This was the first time they had done it. They were responsible. They were trained. They were responsible to take care of this machine. They had this manual in their office, but they never looked at it. They had never done this before. They didn't know the procedures. This is a huge machine. It is mounted on a trailer that can be pulled by a tractor trailer. It's 48, 49 feet long. It's a tremendous machine. Carrier, who manufactures the machine, has this manual that's very detailed, and the record shows that there's over 130 pages in this manual. But the very first thing warns people of the danger, the hazard of system pressure. This would not have happened if either of two things had been done. Number one, when they shut down the machine on December 21st of 2016, if the defendants had put antifreeze in the water system of the machine, like the manual called for, and like stickers that were on the machine specified was necessary. If they had used antifreeze, this wouldn't have happened. That's agreed by all the parties. Secondly, it wouldn't have happened if they had removed the high pressure refrigerant gas that was in the machine that they knew about. There's 2 pressure vessels, and we'll talk about those in a minute, but there was high pressure refrigerant inside barrels in the water system that these barrels were designed to withstand 220 pounds of pressure per square inch. That's what the pressure from this refrigerant that they knew was there. And if they had removed the refrigerant when they shut the machine down and secured it, this wouldn't have happened. But they didn't either.
Can I ask you a question about,
Yes.
I think what your friends are going to argue is the third way that this tragedy could have been avoided, and that is if Mr. Long had followed his training that he had received and stood to the side of the pipe, of any pipe, before ever removing a cap. Do you agree that there's undisputed evidence that the decedent received that training that was part of a duty of ordinary care that he would have known he had there?
I would suggest to you that he did follow his training. There is no evidence in the record exactly where he was standing. It's been argued that he was standing in front, but there is evidence. But more importantly, if you look at record page 834, Mr. Quate, who was testifying about Mr. Long's training, said it has been argued that he violated his training by the defendants, but they must have missed page 834 because as he was allowed under Rule 30E of the Rules of Civil Procedure, Mr. Quate went back through and read his deposition and clarified and said, if the machine, assuming the chiller was energized, but the chiller had been disconnected from electricity and water for weeks, the defendants had disconnected the water, some electricians had, and it was sitting idle for weeks. And so he did not violate his training. Furthermore, Mr. Quate explained that he would have done exactly the same thing under the same circumstances. So the question is, would a pipe fitter, Mr. Long was a pipe fitter, not an HVAC person, would a pipe fitter under the same or similar circumstances have acted reasonably by doing what he did? Mr. Quate testified he would have done the same thing, as did two other pipe fitters who were deposed.
And on this very point of what evidence there is in the record about where he was standing at the time, wouldn't the document, these are the photographs now, document exhibit 19 and document exhibit 24, which show, 19 shows blood on the concrete, and 24 shows the gravel area where his partner testified he was standing. Isn't it a reasonable inference at summary judgment, as we do take the evidence in the light most favorable to the non-moving party, that those two photographs indicate he actually was standing to the side of the pipe?
I wasn't going to get that deep into the weeds, Justice Earls, but yes. But, you know, it can be argued, but there is direct testimony from Mr. Weston, who was there beside him, that they were standing shoulder to shoulder. And if you can look at the, I think it's documentary exhibit page 15, shows the inlet and outlet pipes at the end of the machine. If they were standing shoulder to shoulder, there's an 8-inch inlet pipe and an 8-inch outlet pipe for water. Warm water goes in the inlet, comes out cool on the other. They were standing shoulder to shoulder, and Mr. Weston said, first, Mr. Long had used a crescent wrench to loosen the nut on the bolt, and at that point they smelled no Freon, and they didn't hear any hiss, and then they proceeded, Mr. Weston was holding a socket, and Mr. Long was in the process of putting a ratchet wrench on, or a socket wrench, at the time when it exploded. Mr. Weston also testified that the cap did not come straight out. Mr. Weston testified that the cap came off at an angle and spun around. And so we submit that that is a question which needs to be decided by a jury. I've been doing this for 44 and a half years, and it's been my privilege. I represented insurance companies for 11 years. It's been my privilege. I've had the privilege to be here before. I've tried plenty of cases, but one thing that I understand is that it's respectfully not up to trial judges or appellate judges to decide facts. It's for the 12. And I think that it's not clear about exactly what Mr. Long did, but there is testimony that from reasonable pipe fitters that he did exactly what they would have done and that he acted appropriately. Now, it's also interesting to note, while we're talking about contributory negligence, that on page 26 of the defendant's brief, they admitted, and I quote, "It was unforeseeable to career pipe fitters," close quote, that this could have happened. Now, foreseeability is an essential element of contributory negligence, and the defendants have conceded that to pipe fitters, this incident would not have been foreseeable. That being the case, we believe on the issue of contributory negligence, it's a jury question. We didn't move for summary judgment. We think this is a case that a jury should decide. We want, on behalf of the Long family, for them to have their constitutional right to a jury trial to let 12 people in Person County decide this case for them.
So let me ask you this question. If it was unforeseeable to pipe fitters that this accident would occur, why would it be foreseeable to the defendants that this accident would occur?
As I began right here, the defendants had this manual that says, safety considerations, insulating, starting up, and servicing this equipment can be hazardous due to system pressure. There is plenty of evidence. We learned, one of the cool things about this, that might not be the right kind of word to use up here, but one of the neat things about this job is that we learn about a lot of things. We learn about HVAC machines, how this chiller works. And we learned from the defendants who are HVAC trained. We learned that they knew that there was high pressure refrigerant in these 2 barrels on the machine. 2 barrels that are designed to withstand pressure. I would commend you to plaintiff's documentary exhibits 98 and 100. They show one end of one of those barrels. And the 8-inch opening there is where the water comes in or comes out of that barrel. That's the out exit. But the defendants knew that these barrels were filled with the high pressure refrigerant inside a chamber that was designed to withstand the high pressure. But they also knew that inside those barrels were hundreds of thin copper tubes. And the water would flow into the barrels, go through these copper tubes. The refrigerant that was there all the time surrounding the tubes would cool the water as it went along, 10 feet. Then it would flow into an 8-inch pipe, go into the next barrel. Again, surrounded by refrigerant, and it flowed through the tubes. So they knew. In fact, when they did the job, they did what they characterized as a nitrogen purge on the chiller barrels. Now, we don't know where they came up with the idea to do a nitrogen purge because the defendants admitted that there was nothing in the manual that they had never looked at about that. But they ran nitrogen gas through there because, and they testified, and it's quoted in our brief, they wanted to get all of the water out of these tubes inside the chiller barrels because the day that they drained it was December 21st, 2016. Now, there was an argument by the defendants, well, this wasn't a winter shutdown, but each of the defendants, because they know general things, testified December 21st is the first day of winter. And they knew that the machine was going to be shut down according to documents that are in the records for 60 days. So they were shutting the machine down in wintertime. And they testified specifically that they intended to get the water out of the tubes because if the water remained in the tubes and froze, it would break the copper tubes that were surrounded by refrigerant, and refrigerant could get into the water system. It's already in the water side of the machine, but it would get into these tubes. Mr. Fowler, one of the defendants, he took HVAC training beginning in 1990, and he worked continuously only in HVAC for 26, 27 years up until when this happened. And he said, and it's quoted in the brief, I think it's it may be in the record, I don't want to get this wrong, but it may be page 444, 445, somewhere in there, but it's quoted. He said, I said, did you want to get the water out? Yes. Why did you want to get the water out? So that the tubes wouldn't, the water wouldn't freeze and become ice and break the tubes. Would you have done this? Did it matter because of what time of year it was? Yes, it did. Would you have done it in July? No, we wouldn't have done it in July. Why not? Because it's not going to freeze in July. And then I asked him this question, and it's quoted. Did you remove the refrigerant when you shut down and secured the machine? And he testified, no, because it was open. At that point, they knew that there was refrigerant in the barrels. They had not capped the water pipes, and so he said, no, we knew it was open. It's also interesting, I was looking through in preparation for being here today, I was looking through and saw in the affidavits of Mr. Fowler and Mr. Matthews, two of the defendants, that they said when they came to cap the machine, that they smelled, to smell if they could smell any Freon. It's paragraph 15 in Mr. Fowler's affidavit. It's paragraph 12 in Mr. Matthews. Pages 1734 and 1738 in the record, I believe. And that shows that when they came to cap the machine, they knew that the Freon in the barrels could get out through the water system. We contend that's a reasonable inference, but they went ahead and capped it anyway, and they left the refrigerant in. If they had taken it out, we wouldn't be here. There would have been a trial. Plaintiff might have won, plaintiff might have lost, but there would have been a trial. We're so glad to be here because this gives us an opportunity to answer your questions, emphasize what facts are in the record that are important. The Court of Appeals didn't have oral argument, and as a result, there were some mistakes of fact in the Court of Appeals decision. Now, those are innocent. Nobody did these on purpose, but had we had the opportunity to be there, we would have been able to point out some things and answer questions. I'll give you a couple of examples. This hasn't made it to the North Carolina reports yet, so this is 906 Southeast 2nd. At page 48 of the opinion from the Court of Appeals, it says, this was caused because refrigerant was not added. Well, refrigerant was the 220 pounds per square inch gas that was in the barrels that was there the whole time. It goes on to say, I believe it's at page 47, that no one could have foreseen that antifreeze would be spilled into the pipes. Well, the point is they didn't put antifreeze in there. If they'd have put antifreeze in, it wouldn't have happened. There's also a reference to this occurred because of a chemical reaction that was unexpected. Well, a chemical reaction, this is getting back to my college chemistry when I thought I might be a doctor or something like that. A chemical reaction requires a molecular change. When water freezes into ice, that's not a chemical reaction. But regardless, the defendants knew that the water needed to get out of these tubes because if it didn't, it would freeze and become ice, it would expand, and it would break the tubes. They testified to that.
I understood the reasoning of the Court of Appeals to be, I'm sort of simplifying it here, but that it was the particular injury that resulted that was unforeseeable, that you could sort of think of it as the idea that an engineer or maybe certain chemists and things would understand how this machine, these series of events could lead to the cap exploding off in that manner. But for someone who's just a technician that doesn't have that training, the damage to the machine is foreseeable, but not the sort of sequence of events. This is kind of the Paul's graph that, Cardozo's opinion we all studied in law school situation of the explosive knocking the scale down at the train station sort of thing. And that's what I understood their reasoning to be.
Well, respectfully, Plaintiff's Documentary Exhibit 51 warns of safety considerations due to system pressure. The defendants did appreciate that there was high pressure refrigerant, that it was in the same vessel as these tubes. They understood if the tubes broke that the refrigerant would get in there. Paul's graph, as I remember, boy, it's been a long time, but Paul's graph was two porters are helping somebody get on a train, and somebody drops a suitcase, and it happens to have fireworks in it, and it goes off, and it knocks down a scale on another platform, and the scale falls over and hits somebody. that certainly, I get that. But here where you have men who understand how this machine works, who are responsible for the 7 HVAC, 7 buildings, they understood. They in fact said, we knew. Mr. Fowler testified, as soon as I heard what happened, I figured it out. I knew what had happened. If he could understand it afterwards, he certainly could have understood. If they had read this, if they had followed this manual and the warning stickers that were on the machine, they said we didn't see them. Mr. Matthews testified, it's quoted, I can't remember the page number, but Mr. Matthews said, if I'd have seen that sticker, I would have gone to talk to my superiors about adding antifreeze. Granted, it does not say if people are shutting down the machine in winter and they fail to read the manual and they leave the refrigerant in there and they leave water so that it can freeze and damage the machine and they cap the machine that a cap might blow out and hit somebody a month later, it doesn't say that. But it's my understanding from the decisions that it's not necessary to foresee the precise injury. What we know is, had this machine been taken care of, this machine, there's a straight line between the defendant's negligence and the injury. And that's all I know about Paul's graph. Dean Byrd might remember more of it, or rest in peace, but anyway, that is the Paul's graph piece of it as I understand it. But this is not an attenuated situation like that was. I think that it appears that y'all understand well how this machine works, but warm water comes into an inlet pipe, 8-inch pipe, goes around the machine, goes through these 2 barrels where the refrigerant is. Defendant's brief uses the term over and over and over about inadvertent pressurization of the chiller. Inadvertent pressurization of the chiller. The chiller was pressurized from the get-go. They knew that. The manual says there's system pressure. They knew that there was high pressure refrigerant in the chiller already on the water side. So it's not like somebody came and put pressure in there. They knew about it. And had they taken it out, this wouldn't have happened. If they put antifreeze in, so when it froze, the tubes wouldn't have broken. It wouldn't have happened. If the court has any more questions, I'll be happy to try and answer them. I appreciate the opportunity to be here, and we would request that we get our chance to take the Long's case to their citizens in Vance County. Thank you.
Thank you, counsel. We'll hear from the appellee.
Good afternoon, Your Honors. And my name is Jonathan Hall. I'm here with Patrick Meacham. We're both here on behalf of the appellees in this case, Dennis Kinsler, James Fowler, and David Matthews. I will be addressing the portion of the case on proximate cause, and my colleague, Mr. Meacham, will be talking about contributory negligence. So I'll probably try to give him at least 10 minutes toward the end of my argument to do so. This court may recall that the case was here about 4 years ago, the same case, and it was here at the time on an order from the trial court that dismissed the case pursuant to Rule 12b-6. And there were a couple of issues at that time. The first issue, I think that was before the court, was whether these defendants should have sovereign immunity. That was a separate argument from what we're dealing with today. The other issue was foreseeability, whether the complaint had alleged sufficient facts from which a jury could find that the alleged negligence of the defendants was a foreseeable result of the death of Mr. Long. This court, with Justice Earls authoring a majority opinion, found that the complaint, if you take all the allegations as true, stated a claim upon which relief could be granted in North Carolina, and the court sent it back down and said this case should proceed through discovery. 16 months of discovery ensued. And at the end of that, and just before this case came off for trial, we'd filed a motion for summary judgment. And at that time, the trial court heard the evidence, heard the arguments of counsel, and ruled that the plaintiffs were unable to forecast a genuine issue of material fact upon which relief could, or, a genuine issue of material fact for the jury, and therefore summary judgment was appropriate for the defendants, now appellees. The Court of Appeals, of course, affirmed that, and we're asking this court to do the same thing. As the court knows, a plaintiff may not recover damages in a wrongful death case in North Carolina without proving that the defendants were negligent and that such negligence was a proximate cause of the alleged death. Our pattern jury instructions define proximate cause as a cause which in a natural and continuous sequence produces a person's injury, and is a cause which a reasonable and prudent person could have foreseen would probably produce such injury or some similar injurious result. Proximate cause, as the court knows, is a matter of foreseeability. The court, in this case, the trial court, found that the plaintiff was unable to forecast evidence that these defendants should have known that it was likely that their failure to put antifreeze in this system would have resulted in some sort of pressurization of the pipes, which we inartfully perhaps call it pressurization of the chiller, but it was the pressurization of the pipes that was the issue here. And the trial court properly found that the plaintiff could not raise a genuine issue of fact as to whether these three defendants should have foreseen that this could happen. The most telling, and Mr. Thompson, of course, has been in front of many courts, as have we, but I think the most telling part of this case is in the transcript of the hearing before the trial court. And we had argued our motion for summary judgment. They'd argued their opposition. And at the end of Mr. Thompson's arguments, His Honor Judge Dunlow looked at Mr. Thompson. He said, "Can you point this court to any evidence in this record that this kind of thing has ever happened before?" And Mr. Thompson said, "No. There is no evidence in this record that this type of thing has ever happened before, that anyone's ever heard of it."
And can I just ask you a
Yes,
question about that?
Yes, Your Honor.
Because you made that argument in the briefs. Doesn't the significance of that depend on whether or not HVAC-trained technicians who are shutting down a chiller unit like this have ever disregarded the instructions to put antifreeze in the unit because they can't completely drain the water out?
Your Honor, I'd argue that it does not. And first of all, it's important to understand these gentlemen were maintenance people at NC State. They were in charge of Zone 6, which was all the buildings on the campus over in Centennial Campus, okay? These were not Carrier certified technicians. In fact, the record has many records in there from Carrier that whenever NC State had an issue with this unit, they called Carrier, and Carrier would send certified technicians. To impart our clients with this expertise of a certified HVAC technician from Carrier is just not proper, and it's not in the record. Our clients, again, were mostly maintenance people. I think Mr. Kinsler said he primarily worked on electrical issues. He'd worked on some HVAC machines, but mostly on the water side, okay?
But doesn't that just go to, and I'm sorry to interrupt you.
That's my fault. No, it's my fault.
Doesn't that just go to, if they knew they had the manual. There's testimony that they knew the manual was there,
Yes.
but they didn't look at it. Doesn't that go to whether or not they should have attempted to do what they were asked to do if they didn't have the requisite training to actually do it?
Well, Your Honor, again, I'd argue that does not, okay? And the reason being, there was nothing in the manual that said, and we'll assume for the sake of this argument today, that it was negligence for them not to have looked at the manual and for them not to have put antifreeze into the chiller system, okay? We'll assume for the sake of argument that it was. The question is that negligence, did it foreseeably lead to the kind of condition, the chain of events that led to Mr. Long's death? And we'd argue that it did not. I lost my train of thought, Your Honor, but again, but there was nothing in the manual.
Because I think with Justice Earle's, the question, I have this, I'm trying to wrap my mind around the same thing, which is, I'm trying to figure out what degree of knowledge do we have to assign here for purposes of assessing foreseeability? And the point would be, well, if you're, to my point about, well, an engineer would know never to do this. Well, the argument would be, well, if even it's just someone that has a lot of training in HVAC maintenance, if someone like that would know, and the argument is, well, you should have had that requisite training in order to be even working on the machine. And then we therefore say, so it wasn't foreseeable because you didn't have the training, but the reason it's negligence is you should have had that training to work on it. It seems to me like there's something wrong with then saying, well, we're going to say it's not foreseeable. It would have been foreseeable to someone who had the training and was potentially, I'm just saying, and that isn't that, so isn't it then relevant that you're saying your clients maybe should have worked on the machine without that training?
All right, Your Honor. And so, again, they weren't being told to work on the machine. If the court will recall, the order was the pipe fitters, Quate, needed to construct some natural gas lines underneath the loading dock. And this trailer is a big tractor trailer, as Mr. Thompson pointed out. They needed to move over by about 10 feet. They weren't working on it. They were just asked to drain it, okay? And so they went to drain it, and they thought they drained it completely. And the court will also recall on the record, Mr. Quate said about 6 days after these gentlemen drained it, they actually moved the trailer up and down the ramp. Okay, they had to move it forward, move it over about 8 feet, and they backed it up. At the time, it was on an incline. The pipes were open, and no water came out. Everybody thought it was empty, okay? The court will see also in this record, we do have testimony from people who were much more accustomed to working on chiller units than any of our defendants, any of our clients. Quate testified he was a certified pipe fitter. He'd been certified to work on chiller units. He'd been doing this for over 30 years, Mr. Quate did. Nate Weston, who was one of Mr. Long's co-workers who was standing right there with him, had extensive experience working with chiller units. Both of those gentlemen testified that even with their knowledge of these units, and everybody knows that for the sake of this argument, we'll concede that anyone who works around HVAC units, generally speaking, knows they're pressurized systems. And the warning that he keeps talking about on the manual, that just general warning on the front of it, says, hey, if you're going to work on this system, be careful, it's pressurized, okay? There were no warnings anywhere in the manual that said if you fail to drain the water or completely, or if you fail to add antifreeze to the system, there's a chance that the tubes could eventually freeze and that they could then expand and explode, and that refrigerant could get out and mix with the water, and that if the pipes are capped, it could create pressure in the pipes. There is no warning about that whatsoever, let alone that it could hurt somebody. And
Well,
so
this seems to me to be the key question, is how obvious should it be to a reasonable person that if that piping within the machine cracked like that, that somehow it could penetrate into the parts of the system that are pressurized. If the piping itself is sealed, you'll still have a pressurized environment. And then if you suddenly remove the cap, ordinary people know what happens when you pop the champagne cork. And so I'm just trying to figure out, is that something that a reasonable person could not foresee, or is it something that should be somewhat obvious? How do we know?
Excuse me, Your Honor. So the plaintiff, the burden is on them to produce some issue of fact that they should have foreseen that, okay? They've got to have some evidence in the record somewhere from somebody who says they should have foreseen that. The evidence from their expert, Dr. Eberhardt, he said he's never seen this before, okay? He's the expert. He says, I've never seen this before. And he said, certainly I wouldn't expect any of these three gentlemen. He said, I'm not in a position to testify that any of these three gentlemen, even though he'd read their depositions, he's not in a position to testify that any of these three gentlemen could possibly have foreseen that somebody would get hurt by this, okay, that it could lead to the chain of events where somebody could get hurt. So again, the burden is on them to produce some evidence somewhere that they should have foreseen this. It's not Mr. Thompson standing here talking about the reaction, okay? It's got to be competent evidence for a jury. And I will point out, the only person in this entire case, if you look at the record, who has suggested that it was foreseeable when these gentlemen worked on, or they drained the chiller, okay? The only person who suggested it was foreseeable that the failure to put antifreeze in there could lead to some injury is Mr. Thompson. There is no competent evidence in the record where any witness has said that. None of the expert witnesses have said this. And so that's what the trial court found was, Mr. Thompson, that's an interesting argument you make, and it may well be true, but you've got to forecast some evidence on which I can rule that, yeah, a jury could look at that and say, these guys should have known that. Okay, this is not some sort of res ipsa situation, Your Honor, where a jury could just say, hey, well, because this thing blew up, and it's from this fact that these guys, when they were draining it, didn't add antifreeze. Again, that's not something that's just so self-evident that the court should presume that, or that the law would presume that. There has to be some forecast that, Your Honor, we've got this transcript, we've got this witness who said this, that it's possible this could happen. Nobody's ever seen it before or done it. And so, again, the burden is on them to do that. And if you
And
look at
Counselor, I have a question as a
Yes, ma'am.
follow-up, somewhat, certainly in this dialogue, and
Sure.
it has to do with the Paul's graph analogy.
I'm ready.
And if I'm incorrectly stating the position of the folks on the other side, I'm sure I'll be corrected during rebuttal. But it's my understanding that the argument they're making is they did not have to forecast a specific injury or a specific situation. Instead, the fact that you have this pressurized unit, it's an incredibly dangerous unit, and something bad could happen if it's not treated properly, if it's not handled with due care. That actually is the old Kinsman case, which is the companion case that most people learn in first-year law school with the Paul's graph case. So how do you address their argument that it would be foreseeable that something really bad would happen, and then certainly something did very tragically happen?
Your Honor, first of all, I'll take a little issue with your statement that it's an incredibly dangerous machine. It should not have been an incredibly dangerous machine. When you're working on the machine, you're a technician, you're going to be dealing with some of these pressurized systems. You need to be careful, okay? But there is nothing about that chiller unit that made it an incredibly dangerous machine. Being around it, hooking up to the buildings, et cetera, you're not in danger. So that would be number one. Number two, the Court of Appeals, the dissent there, I would argue, is misplaced in that Judge Hampson said it's, and he's right, and I believe the court obviously stated the concept, the doctrine correctly, that proximate cause need not be foreseeable as far as the actual injury that occurred, so long as it's foreseeable that there could be some other similar injurious result. There is nothing in our record or in the warning labels, in the manual that they keep talking about, and certainly not in our client's experience, okay? And he asked them all kinds of questions, depositions about their experience. There is nothing in any of that from which you could say that it was foreseeable that any injurious result could have come from them, their failure to put antifreeze in the system.
But
You've got to have some, I apologize, Your Honor.
well, again, I hate to interrupt you, but
No.
the manual does have numerous warnings that say electrical shock can cause personal injury and death. High inhalation of high concentrations of vapor may cause irregularities, unconsciousness of death, misuse can be fatal, warning. So there's numerous ways where they say if you don't handle this machine right, it could kill you.
Absolutely, Your Honor.
And so then that brings me to Hairston versus Alexander Tank and Equipment Company, the 1984 case, where this court said, it is well settled that the test of foreseeability as an element of proximate cause does not require that the defendant should have been able to foresee the injury in the precise form in which it actually occurred. And then they quote Hart versus Curry in a 1953 case, all that plaintiff is required to prove on the question of foreseeability in determining proximate cause is that in the exercise of reasonable care, the defendant might have foreseen that some injury would result from his act or omission, or that consequences of a generally injurious nature might have been expected. And in that light, it seems to me that of all the warnings in the manual, the thing that the manufacturer put actually on the machine itself said, caution, all the water may not come out, you can't drain this completely, and so it seems to me at a minimum, that's like the most important of all these warnings, and that one they disregarded.
So a couple things, Your Honor. First, again, we go back to the court, and you read the opinion correctly, where the concept of as long as it's foreseeable that there's some similar injurious result exists, that should satisfy the proximate cause element. That's where, again, though, there is nothing anywhere in this record or anywhere in the warnings that suggests a failure to properly drain it or a failure to add antifreeze could lead to any injurious result. It's telling, Your Honor, that with all those warnings in the manual, and the court has seen or operating manuals from every type of machine, I'm certain, that's come before the court, there are always warnings everywhere in these things, okay? They certainly knew how to say that caution, electric shock, someone can get hurt if you're not careful around the electricity. They certainly knew how to say caution, you can be burned on various things. They knew how to caution the user who's going to be working on the machine. They knew how to caution them about the potential for injury. It's telling that where this specific, the instructions for draining the machine, winterizing the machine was, there is no such warning. The warning says caution, if you fail to adequately drain the machine and if you fail to add antifreeze, you could damage the machine. Okay, that's all it says. And again, Your Honor, going through the testimony from their experts as well, there is no warning anywhere that says your failure to drain this thing could potentially cause pressurization and could hurt somebody.
So I guess
Yes, Your Honor.
I know I keep coming back to this.
That's okay.
This is what I'm hung up on.
Yes, sir.
So it certainly seems to me the case that it's absolutely foreseeable that there's going to be property damage, injury to the machine, because ordinary people understand. We all know that if there's water in a pipe, the pipe freezes. What's one of the things that could happen? The pipe will burst. But I guess what I'm trying to figure out is, can you then make the next step, which is, if you are on notice that there are pressurized components within the machine, you can understand that somehow the freezing of the water within the pipes can lead to some kind of damage that will then cause the pressurized portions of the machine to leak into the pipes, pressurizing the pipes so that if someone tries to take a cap off a pipe, there'll be bodily injury. And that, it seems to be the heart of this case, is figuring out, is that something a reasonable person can foresee, or do you need some sort of training beyond what the defendants have here to foresee that?
Your Honor, you said it's absolutely foreseeable that there could be damage to the machine, and I'd argue it's not absolutely foreseeable, but arguably, if someone had sued these gentlemen for damage to the machine because those chiller pipes had expanded and been damaged, okay? I'd argue there's a warning in the manual.
Well, doesn't the warning itself say that, make it foreseeable? I mean, the warning does, that's what the warning is warning you
that there could be
about.
damage to the machine.
Yeah.
Yes. I'll go back a little bit to Paulscraft, though. But for causation surely is there, okay? But for. And there was some argument in the appellant's brief about inconsistencies in deposition testimony of the defendants versus the affidavits that they submitted. And we submit to the court there are no inconsistencies, because had Mr. Thompson been in the Paulscraft case, and had he been taking the depositions of these railmen, okay, I'm sure he would have started off by saying, and sir, you knew that train was moving, didn't you? And the railman would have said yes. And you know that jumping on a dangerous train or on a moving train is dangerous, don't you? And I'm sure the railman would have said yes. And you know that if someone's carrying a bag and they try to jump on a train, that bag could fall, don't you, sir? Sure. And you know that if that bag has explosives in it, and that bag falls on the train tracks and gets run over, it could explode. You know that, don't you, sir? And I'm sure the railman would have said, sure, okay. And you know that if that explosion had taken place on the tracks, it could have damaged some set of scales further down the platform. You know that, don't you, sir? And I'm sure the railman would have said, an explosion on the tracks? Yeah, okay, it could damage the platform. Well, it could damage the scales. And you know that if those scales had then fallen, it could have landed on someone like Ms. Paulscraft, don't you, sir? And I'm sure the railman would have said, sure, okay? And so then Mr. Thompson would have stood up there to Judge Cardozo and said, Your Honor, that's foreseeability, because they answered each one of these things that they knew these facts could happen. And therefore, when he's trying to help this guy get on the train, it was foreseeable to him that the scales eventually were going to get blown up and fall down on Ms. Paulscraft. That's the argument they make, okay? And that's but for causation, but it's not foreseeability. And the fact is, the Paulscraft case says we've got to cut it off somewhere. At some point, it's got to be what is reasonably foreseeable to the actor at the time they did the alleged negligent act. And, Your Honor, again, we argue in this case they have got to present evidence from which a jury could say, you know what, this engineer says it's possible and that was even foreseeable to these guys that when they did this, it was going to cause this chain reaction that led to a pressurization of these pipes. Or we've got these gentlemen from Kuwait who've been working on this type of thing for a long time, and they said, yeah, I mean, that's pretty well known in the community, or this well known in our industry. Kuwait couldn't even say that. I mean, so again, Your Honor, they've got to raise some issue for the jury to say, you know, there is a fact here that we can at least argue about and that we can base a verdict on, okay? And so, again, he talked about the court's not supposed to decide issues of fact. Well, I totally agree, okay? The court's place is not to decide issues of fact, but there has to be an issue of fact. And so the court has to decide if there is an issue of fact. If there is, then it's not your place to decide it. So
can
yeah, I hope
we,
that answered your question, Your Honor.
can we rule for you on proximate cause without being inconsistent with what this court said the last time this case was here about proximate cause?
Yes, sir, Your Honor, because the last time the case was here, the standard was we take the allegations of the complaint as true. And they alleged in the complaint that these defendants knew or should have known that by failing to put antifreeze in the system, it could lead to the death of Mr. Long or some serious or similar injurious result. Now we're at the summary judgment stage. We've been through all this discovery. We look at the evidence in the light most favorable to the plaintiff, but there still has to be evidence there. And so this court back then said, if we look at the allegations as true, it states a claim. Well, now we're here to test the strength of their evidence to see if those allegations were true, and they're not. There's no evidence to support their allegations, Your Honor. So I submit to you it would not be at all inconsistent, and that's why this court can, in fact, rule in our favor and support and affirm the trial court. If there aren't any further questions on foreseeability, I promise Mr. Meacham I'd give him a few minutes on contrib. Okay? Thank you very much.
Good afternoon. May it please the court. I'm Pat Meacham, and I'm here to address the issue of contributory negligence of Mr. Long in this case. Given that Mr. Hall did in fact leave me just a few minutes, let me jump right to the issues of contributory negligence. The overwhelming evidence in this case is that Mr. Long was negligent in the performance of his duties. And to your point, Justice Dietz, we are looking at someone with Mr. Long's training, education, and experience, an experienced pipe fitter who had been trained by his company on pressurized systems, an experienced pipe fitter who had gone to training sessions from independent training organizations, an experienced pipe fitter who was required to comply with OSHA standards in his activities.
What's the impact of Mr. Quate's deposition changes?
Well, what I'm going to talk about, Justice Allen, has very little impact on any of his edits to his deposition testimony. In fact, I made sure to go back and look at those changes from his errata sheet. And what I'm going to talk to you about this afternoon, the changes to that errata sheet do not affect anything I'm about to tell the court. So, first, Mr. Long assumed the unit was not pressurized. We know that Mr. Long, from Mr. Quate talking about his training, that Mr. Long knew how chiller systems worked and they could be pressurized.
Can I just, I'm really wrestling with this point. If this injury, if this type of accident was not foreseeable, how is it possible then that he could be contributorily negligent for not foreseeing this kind of injury?
Well, there are two different sets of training here that we're talking about. We're talking about how were the defendants trained and what was their background. And then we're talking about the training of Mr. Long, which was separate from the training of maintenance people at NC State.
But we've just been told that no one had ever seen an accident like this and that no one could have foreseen this happen.
And Your Honor, if there is no foreseeability as to anyone, we don't need to address contributory negligence because the jury would never get there, right? So Mr. Long's training and why it would have been foreseeable to him, he knew that refrigerated lines could crack or fail if they became frozen. He knew that when working on a pressurized system, he needed to make sure the pressure was released before he started working on that system. Mr. Quate testified that Quate's own safety manual did not allow an employee to rely on the work of anyone else when dealing with a potentially pressurized unit. And perhaps the most important testimony in the case is that of Nate Weston, Mr. Long's coworker, who testified, "You've got to verify that it's not pressurized. Yes, you have to verify that it's safe to work on." Mr. Long didn't do that. One of the things that the appellants point to.
What do we do with the testimony that Mr. Quate testified that another way to check for pressure is to do exactly what Mr. Long did, which is to loosen a nut a couple of turns and bleed the pressure off that way?
That would be applicable, Justice Riggs, if that in fact is what Joe Long intended by that activity. But that is not what Joe Long intended by that activity. Joe Long intended to remove the cap by using that crescent wrench. He never intended to be doing a safety test. If you look at the deposition of Nate Weston, who was right there by his side, in fact, Mr. Weston testifies on 4 different occasions in his deposition testimony that the crescent wrench would not fit up in there. That's at page 92, 93, 94, and 97 of his deposition testimony. And at page 96, Mr. Weston testified he wasn't really able to turn it with the crescent. So at best, there's conflicting testimony. But the fact of the matter is that Mr. Long wasn't using that crescent wrench to perform some kind of test. He was using that crescent wrench to remove the cap.
Seems really hard to me to talk about the intentions of a dead man doing an action that his experienced coworker says would have let out some of the pressure. I mean, can that be the question for contributory negligence?
Well, the coworker that was there, right by his side that day, said he tried to use a crescent wrench and it didn't fit. He testified under oath 4 times to that. And he testified that he could never really get it up in there. So there is some question of whether the crescent wrench was ever used. But the fact of the matter is the crescent wrench wouldn't turn it. Mr. Quaid testified, who was not present, testified that this could be a way you do it. But Nate Weston, who was present, testified the whole purpose of using the crescent wrench was to remove the cap. So that's why it makes a difference about the use of the crescent wrench. It wasn't being used for a test, according to the coworker that was there at the time. So the second thing that Mr. Long failed to do that was negligent is he failed to use a bleed valve. Mr. Quaid testified that Mr. Long could have checked the pressure on the system by opening one of the ball cocks, and if he had done so, it would have reflected that there was pressure in the system. He did not do this. Mr. Quaid said that this would have been an easy way for Mr. Long to determine if the system was pressurized.
But wasn't there also testimony that there wasn't that kind of valve on this unit? And it seems to me we are just talking a lot about what inferences to draw from varying testimony, and why isn't that for the jury?
Yeah, this is not an inference, Your Honor. Mr. Quaid testified twice there was not a pressure relief valve, but at page 242, or pardon me, page 118 of his transcript, which is page 700 of the record, he acknowledged that there was a ball cock present and that Mr. Long should have used it to determine if there was pressure. So 2 times, Justice Earls, he says the pressure relief valve is not present, but then he does acknowledge the presence of a ball cock that could be used to relieve pressure, so there's no inference there. The last piece is the positioning of Mr. Long. Up until 45 minutes ago, there has never been a contention that Mr. Long was not standing in front of the pipe. The training was clear that Mr. Long should not stand in front of a pipe.
Thank you so much, counsel. Rebuttal.
Good afternoon. My name is John Paul Godwin, here on behalf of the appellant in rebuttal. While it's fresh on my mind, I think it is important, as was mentioned by, I believe, Justice Earls, that Rusty Quaid was shown a picture of the machine, and he testified, and this is in the record on page 699, that he did not see a pressure valve. Nate Weston testified, and this is on page 922 and 923 of the record, that there was not a mechanical hand-driven pressure release valve. So at best, we have conflicting testimony about the existence of a pressure release valve. I think it's important when we're talking about what these men did, it is important, especially with contributory negligence, that what would a reasonable, prudent pipe fitter have done in this situation? And we know what a reasonable, prudent pipe fitter would have done because Rusty Quate testified under oath that he would have done the same thing. With regard to the positions of Mr. Long, there is no evidence in the record that points to where exactly Mr. Joe Long was standing before he was fatally struck. The only reference is on page 705, I believe, of Rusty Quate's deposition, where he said he didn't know where Joe was standing. Joe Long was killed because of system pressure. System pressure was warned on the first page, first sentence of the first paragraph of this manual as being hazardous. Now, both sides this afternoon, have spent most of the time not really arguing case law. We argued Paulsgraf, which took us back to law school, but we're arguing facts. The mere existence of these facts, respectfully, demonstrate that an issue exists for trial. He was killed by system pressure. It was specifically warned of as being hazardous in the first sentence, as I said, under the heading safety considerations. System pressure in this 48-foot long chiller is hazardous to human life. There was system pressure in it because there was high pressure refrigerant gas in the barrels. Experienced HVAC workers, and these were not just maintenance guys, these were HVAC trained technicians. The record reflects in Mr. Fowler's deposition testimony that he had over 25 years in HVAC experience. He testified in his deposition that he had experience working with high pressure refrigerant gas. He knew the dynamics of high pressure refrigerant gas. It was their job, it was their business, it was their duty to know, yet they chose to leave that high pressure refrigerant gas in the system. They knew about the gas, and they also knew that it was important to get the water out of that machine. They knew that the cooler barrels were surrounded by that high pressure gas, that they would break if it froze. That's why they did the nitrogen purge. They were aware that if water froze in the cooler barrels, there could be a potential of fracture for those cooler barrels. So when high pressure refrigerant gas is in it, the system is pressurized. So the system was pressurized from the first time that these defendants touched this machine. The system pressure was not inadvertent. Leaving the water in it was. The hazard of system pressure warned of on the first page of this manual was foreseeable to the defendants, and system pressure is what killed Joe Long. Your Honors, as stated by my co-counsel, we haven't moved for summary judgment. The issue is, in this case, is whether or not there are issues of fact to be tried by a jury. There are over 2,000 pages of discovery. Multiple depositions have been taken. We are simply asking that this case go to a jury trial, that this estate, this family, be entitled to put on evidence to have a jury of their peers, as guaranteed by the Constitution, to have them hear the case and decide. And Your Honors, I'd be glad to answer any other questions that the court may have. Thank you.
Thank you, counsel. Mr. Clark.
Yes.